Morning, good afternoon, and welcome. Thank you very much for attending this joint webinar that the ICDR, along with the ICDR Young and International, is hosting today with the IDR group. Just a quick word about the ICDR Young and International. We have members around the world and conduct programs routinely. A great many of them can be found on the website at icdr.org under educational resources. If you're interested in joining, you can also find the application there. Today's webinar is going to feature a roundtable discussion of the recent revisions to the ICDR International Arbitration Rules. We have a distinguished panel joining us to discuss various provisions with their various perspectives. But first, I'd like to introduce my co-host and co-organizer, Anthony Connerty. Anthony is a barrister in practice in chambers in London. He's acted as counsel, arbitrator, and mediator, international arbitrations and mediations, seated in countries literally all around the world and under the rules of various international institutions, including the ICDR, the LCIA, the ICC, CTAC, and the SCC, to name a few. He also sits in ad hoc arbitrations under the UNTITLED Rules. He's acted as counsel in arbitration-related litigation in London and in the Turks and Caicos Islands, and as an advisor in arbitration-related litigation in the courts of the People's Republic of China. His areas of experience include complex international multi-million US dollar cases involving general commercial disputes, oil and gas, metals, cotton, banking, and online disputes. And he is head of the IDR group. So Anthony, welcome, and I'll turn it over to you.
Well, Louis, many thanks indeed. We're delighted, the IDR group, to be joining with you on this webinar. If I can briefly just tell you a little about the group. The IDR group is based in London at the International Dispute Resolution Centre in Fleet Street, which is close to the law courts in London. The membership of the group is made up of international dispute resolution specialists. The members are arbitrators, lawyers, and other professionals from a number of countries around the world. And we have members in nearly 20 countries worldwide. The experience of the members reaches into the state level of international dispute resolution. Members have sat as judges and arbitrators in the International Court of Justice and the Permanent Court of Arbitration in The Hague, and in the International Tribunal for the Law of the Sea in Hamburg. And members have also sat as arbitrators and acted as advocates in the world's major commercial centres, including Beijing, Cairo, Geneva, London, Paris, and Washington. Now, the group has recently launched a new website, the idrgroup.global. And the purpose, or the main purpose of that, is to act as a platform for our series of webinars. And we started with an energy webinar in April, then an art law webinar in May, and now we are delighted to be joining the AAA IDRC webinar dealing with the 2021 rules. So many thanks indeed.
All right, thank you, Anthony. Would you like to introduce our co-panelists?
Yeah. Can I first introduce Ryan Robertson? She is the chair of the ICDR's Rules Revision Committee. She's an international partner at Locklord LLP, Houston, Texas, in the United States. She holds a JD and an LLM in international economic law, and she acts as arbitrator and advocate in international and domestic arbitrations. She is experienced in cross-border commercial disputes involving a variety of oil and gas issues, franchise law, partnership, sales, contracts, including those governed by the United States Convention on Contracts for International Sale of Goods, and commercial contracts pertaining to manufacturing, supply, warranties, and project development. And recently, the United States Department of Trade selected Anne as one of 10 arbitrators appointed by the United States to serve as dispute settlement panelist pursuant to Chapter 31 of the United States Mexico-Canada Agreement. And Anne is president of the Chartered Institute of Arbitrators and a past member of the Board of Trustees of the Chartered Institute and a past chair of the North American branch. Now, can I welcome my colleagues from the IDR group. Professor Loukas Mistelis is the Clive M. Schmidhoff Professor of Transcontinental Commercial Law and Arbitration, and he's a former director of the School of International Arbitration at the Centre for Commercial Law Studies at Queen Mary University in London. And he has practiced law in Germany, Greece, and the United Kingdom. He's also advised several UK government agencies and international organisations, including the United Nations and the European Bank for Reconstruction and Development on law reform for various secured transactions, legislative projects, as well as arbitration and ADR reform. And my fellow colleague, John Fellas, who is with you in New York. John Fellas is an independent arbitrator. Until 2020, December 2020, he was a partner and co-chair of the International Arbitration Group at Hughes, Hubbard and Reed, LLP in New York, where he practiced for over 30 years. John has acted as counsel and has served as co-arbitrator, chair or sole arbitrator in arbitrations all over the world under the major arbitration rules and across a range of sectors. John is recognized as a leading international arbitrator by all the major legal directories, including Chambers USA, where he is ranked as one of the best. His reputation is phenomenal and deserved. Delighted to be appearing with all such eminent international arbitration practitioners. Louis, back to you.
Thank you, Anthony. That's great, and welcome everyone. Okay, so before we dive down into the actual revisions, I did want to say what a pleasure it is to have you here, Anne, and the role that you played in co-chairing the rules revision committees. Maybe you can say a word about the committee's approach to this project.
I'd be happy to. And I think that one of the things that we need to discuss, first of all, is that although these rules came out in March of 2021, it was actually a very, very long process. And we began before anyone had ever even heard of COVID-19. So although the fact that the rules do mention remote hearings, that certainly was not the impetus for the revision of the rules. In fact, the impetus was that it was simply time. It had been a while, and there's been a number of developments in the law since the rules had originally been designed. Our committee was comprised of both civil law and common law lawyers. We had members from China, Poland, Germany, the UK, Mexico, and the United States, and we were evenly divided between civil lawyers and common law lawyers. We were also counsel, arbitrators, and 2 of our members are former general counsel. So we had a user perspective as well as the perspective of the counsel and the arbitrators. So with that in mind, that is exactly how we went about doing this. We all went out and researched what were some of the new emerging issues that needed to be addressed in the rules. And then we would meet and we would draft proposals, which then went to the ICDR itself for review and comment. And then ultimately we had a soft launch where we invited members of the arbitration community to attend one of our conferences. And at that conference, we also got comments from them regarding suggested changes. And then ultimately the rules were released in March of 2021.
Great, thank you. All right, so I'm going to start going through some of the actual provisions, and of course the panel will intercede and provide comments as we go through them, especially some of the key provisions. I did want to say from the ICDR perspective, we thought the goals for this project were very important. We had not completed a revision since 2014, our last revision. So there were a number of objectives we had in mind. We wanted to see exactly how the 2014 rules had played out during the period. Of course, transparency, as in 2014, was a major goal. We wanted to make sure that every step the ICDR takes administratively is reflected in the rules. In 2014, we had not revised the mediation procedures. So these were updated in this last revision, which I think were quite effectively done. And we wanted to incorporate, as Anne mentioned, best practices in both arbitration and mediation as it is today, along with process efficiencies and economy aimed at reducing really the time and costs of the ICDR system to the extent possible. So let me dive in first with some of the mediation rule highlights. We did include express verbiage into the fact that you can use video, audio, or other electronic means during the proceeding. That provision was also included in the arbitration rules, and the panel is going to share some of their perspectives on that when we get to it in the arbitration work. We wanted to include some proactive language that the ICDR was going to, in fact, assist the parties in finding a mutually agreeable mediator. We wanted to clearly lay out the duties and responsibilities of the mediators, and I think it was laid out in the proper fashion. For example, mentioning that the mediator is not acting in a fiduciary capacity. And we incorporated a new rule, M9, and this goes along the concept of transparency and efficiency, referencing that we will be having a preparatory conference where the mediator with the parties are going to discuss technology, document exchange, the fact that ex parte meetings will in fact take place as a result of the caucusing. And we added a new provision as well under these rules, and again, the arbitrator's rules, that the mediator will in fact be discussing the issues of cybersecurity, privacy, and data protection. As we all know, we have an extensive amount of data that could be exchanged during these processes. We could be under the requirements of some data protection laws, such as the GDPR. And cybersecurity, we're hearing about hacking all the time. So these issues are right at the forefront, and they need to be discussed as part of every single case. And then finally, and the ICDR has always prided itself on being rules innovators, being the institution that first introduced the access to the emergency arbitrator in 2006. This was done here as well, and in a new provision, M14, which says termination of mediation rules reference the Singapore Convention. And what it is that the parties may actually request from the mediator and the ICDR to issue an attestation that a settlement was actually reached in the course of the mediation to assist with such enforcement. Now, we do know that the enabling legislation has not been implemented in the United States and many other countries that have signed this treaty, but we're certainly hoping that that will be the case, and that this treaty will aid in the enforcement of mediation settlements, similarly as the New York Convention has helped us with the enforcement of arbitration awards. So, Anne, before we leave the mediation rules, can you share some of the discussions regarding the work of the committee as they approach the mediation revisions themselves?
Well, it was interesting. The driving force on the mediation rules was actually from a number of the members of our group who are civil lawyers. And they took the first hand at drafting a lot of the rules that you see today. However, the committee also felt it was very important, as you mentioned, to recognize the Singapore Convention. And if you look at that rule, not only does it reference the Singapore Convention, it also says our other treaties, because there are actually some other laws and treaties that will allow for enforcement of mediated settlements. And one of the reasons we felt it was important to mention the Singapore Convention, besides the fact that it appears that ultimately it will grow, as you mentioned, if you look at the New York Convention, when it came into force in 1959, and you look at the number of signatories for the same time period that you now have for the Singapore Convention, you will see that the number of signatories to the New York Convention was quite small at that time. And of course, now we know that it is basically universally recognized. But one of the main reasons for including the Singapore Convention was also to give the arbitrators, the mediators, the comfort that they could sign the mediated settlement agreement or that they could give this attestation. Because in some jurisdictions, you would not find a mediator signing or giving any attestation. So this was an attempt to give them comfort that this is something that they could do.
Thank you. Any other perspectives from the panel on the mediation highlights?
I mean, if I would make a comment, it's rather unusual to reference a particular text of that nature in the rules, and I can understand the desire of the colleagues who work to that to promote the mediation convention. I think it's unfortunate. One would agree that we only have 6 ratifications, and some of the countries that were in the driving force of the Singapore Convention have not yet taken any action. One of which is the whole group of the European Union, and of course the European Union wanted the Singapore Convention, and one would hope that they will ratify it before very long. But Anne's point that empowering the mediator and giving the mediation a bit more teeth is, I think, something that a lot of people who are involved in mediation processes find desirable. And in that sense, one has to commend the ICDR for taking the initiative and agreeing with the recommendations of the committee and include it. Although in many respects, as I say, that's a conditional tooth rather than active tooth.
Okay, I will add that we have really looked at how and what we can do to increase the use of mediation. In fact, in one of the revisions to the arbitration rules, we've changed the presumption in Article 6 that the mediation will in fact take place. So if the parties are not willing to participate, they have to opt out. So now the mediation is part of the process unless the parties in fact opt out. And we looked at the idea that parties have said participating in a mediation delays the arbitration. Well, not in our case, because it's expected to be conducted concurrently. And as we all know, there is that period of 60 days or so to get the arbitrators impaneled and clearing conflicts that allows plenty of time for a mediation to be conducted, especially in the current models that we're using, which are conducted virtually. So for me, it's just really a no-brainer to participate in it, and international especially. You have an opportunity to understand the other side's case, communicate with the other side, and perhaps you're not doing that early on. And you may resolve some of the elements of the dispute, maybe not the whole dispute, but again, it goes to eventually resolving these disputes as quickly and efficiently as possible. So let me switch over to the arbitration rule highlights. And I think I'll start with one of the ones that I think were very important. It was Article 5, and again, for transparency's sake, and we had been doing this process for some time, but it's the way the ICDR handles challenges and some other administrative determinations. We have a standing committee comprised of a former general counsel, and it has rotating participation of ICDR executives. We meet weekly, usually on Tuesdays, and we discuss issues that have to be resolved, such as challenges. Perhaps the arbitration agreement is silent as to the number of arbitrators or the seat. Perhaps a party is arguing that the filing requirements were not perfected. So the case manager prepares the file, submits the comments that we receive from the parties, and we try to be consistent in our decision-making premises. So that is an important article, and now it's in there reflecting that process. Anne, did you want to chat a little bit about this article? We had discussed the idea of providing the reasoning behind our administrative decisions, and as you know, we have decided not to do so at this point.
Yes, we did have a lot of discussion about that point and others. I think it's important to note that although the IARC has been in place for some time, its role and what it does was largely unknown. So consequently, the community felt that it was important to mention IARC, and it was necessary to mention it for our overall goal of promoting transparency. Although we did discuss whether or not the decision should be made public, in the end, it was decided against it, at least at this time. And there were a number of reasons for reaching this conclusion. As you've explained, Louis, the IARC is composed of very competent professionals with a world of experience in dealing with challenges. In addition, unlike some institutions that give no guidance to the arbitrators regarding what should be disclosed to the parties, the ICDR has an extensive checklist that each arbitrator is required to complete. And the beauty of this checklist is that it alerts the arbitrators and the parties regarding what relationships the ICDR will consider to be significant for purposes of disclosure. In fact, checklists like this help avoid situations such as the one in Halliburton versus Chubb, because the checklist forces the arbitrators to think critically. That doesn't mean that there are no challenges under the ICDR rules. Indeed, there are, but the vast majority of the IARC decisions remain unchallenged at the vacatur stage, and if challenged, are supported by the courts. So the committee felt that at least at this juncture, it was not necessary for these decisions to be published. But of course, that is an administrative decision ultimately, and so it's not been necessarily ruled out for the future.
Exactly. I guess the main premise, as you mentioned, we do think this completes our administrative mandate of having that panel put in place and having the case moving forward. It will take additional time should we had to stop now and start preparing reasoning and sending out to the parties. And I can't help but think that that will open the door to further attacks or other related actions regarding our determination. I don't know, does anyone on the panel have any perspectives on this? Would they like to see reasoning, or do they understand the ICDR's position?
I think that's clearly this is a point where ICDR is thinking about how they can help the parties to move their arbitration forward and how efficiency can be achieved. My colleague Remy Gerbet has written about the functions of arbitral institutions, and one of the points he makes, but particularly looking very much of practice in ICC, another organization in the same business as ICDR, is that some of these decisions are purely administrative and therefore do not require much transparency or much reasoning, but they can be here and there the odd sort of borderline decisions which are almost jurisdictional decisions, for example, whether a matter is within or without the scope of the arbitration agreement. Again, the ICC doesn't do it very often. The Swiss chambers do it much more, and other institutions. And I think AAA is very careful not to, ICDR not to tread that line. To the extent that this line is not touched, I think a short decision without extensive reasoning would be appropriate in more circumstances. And if one looks at what is envisaged, for example, in Article 5, things like the place of arbitration and sort of moving the appointment forward, I think for me that these are certainly arbitration supportive or arbitration administrative decisions, and therefore would not require full transparency.
Just if there's time, Luis,
Please.
two comments on this general area. But first, let me congratulate Anne, who was the chair of the Rules Committee. And I know you were involved as part of the management team, Luis, because these are terrific revised rules. And I think you are all both to be commended, and of course, the rest of the committee and the team. In terms of comments, to go to your specific question about reasoning, it was interesting. A few months back, there is a challenge to an ICC award in the Southern District of Florida, and as part of the exhibits to that challenge, you have the ICC's reasoning on certain challenges to certain arbitrators. These are the Panama Canal cases, and there were various challenges that frankly seemed pretty frivolous on their face. One of the arbitrators was sitting with another arbitrator in an unrelated case, and similarly. But what I found helpful about seeing the reasoning was it actually provides guidance to arbitrators going forward. We don't have a lot of things to look to in terms of disclosures, right? I mean, one is the IBA rules, but but actually seeing the reasoning of institutions is helpful, because you get to see, okay, this should have been disclosed or not, and I think it assists. And on this point, I will echo a point made by Anne earlier about the ICDR is distinctive in having a questionnaire for arbitrators. And most other institutions, basically you are asked to disclose any facts that give rise to doubts about your independence or impartiality. The ICDR, actually, when you are nominated to be an arbitrator in an ICDR case, is a questionnaire. Do you know counsel? Do you know the parties? Do you have stock in the parties? A series of questions, which, as Anne says, it really does force you to think, because sometimes things just don't occur to you. It actually just does force you to think about things critically.
Thank you, John. All right, another article that had some changes to, which I think were very helpful. As I had mentioned, we introduced the access to the emergency arbitrator in 2006, and the article was largely left intact, but some additional reasoning standards were actually included. The petitioner would have to submit why this relief is requested on an emergency basis and needed before the tribunal is appointed. Reasons why the petitioner is likely to be found to be entitled to such relief, and in fact, what injury or prejudice the party will suffer if that relief is not provided. And I'd love to hear, were there other standards or discussions regarding the standards that were finally adopted?
I wouldn't say that there were any other standards that were necessarily discussed and jettisoned, but I would say that the committee felt very important. Two very important criteria needed to be restated and or expanded. And the first is the reasons why the relief is required on an emergency basis before the tribunal is appointed. And that's key. I know from my own experience of being an emergency arbitrator that often you would receive a request, but the request doesn't show why the emergency relief needs to be given at that point in time before the tribunal is appointed. Also, we added what injury or prejudice the party will suffer if the relief is not provided. So ultimately, this new Article 7 with the new supplements and amendments is to give both the parties and the arbitrators a clear roadmap of what is required as a threshold matter in order to be entitled to emergency relief.
Thank you, Anne. Any other comments regarding the standards? All right, I'll move on. Did you want to say something, John? I'm sorry.
The only comment I have is, most arbitration rules, except the UNCITRAL rules, to my knowledge, don't actually set forth standards for the granting of interim relief generally. And I know emergency arbitrators is a different issue to interim relief. Interim relief is issued by the panel once constituted. Was there any discussion of, is it possible that the standards now that you've set forth for emergency relief may get imported in applications for interim relief, given that there are actually no explicit standards in the rules? I mean, parties may rely on them. That's really my point. And they may say, well, we're going to rely on these standards now that we're applying for interim relief.
We'll have to see and track how that plays out. Anne?
Well, I was going to say that is an extremely interesting point, and not one that I think we even considered. And so I do think we're just going to have to see how that particular idea plays out in the future.
All right, thank you. Moving on, regarding joinder, which was included in the 2014 version, but we had seen that there were some instances because the 2014 simply did not encompass the possibility of appointing an additional party after the arbitrator was appointed. So it was tweaked here to allow the appointment of an additional party after the arbitrator's been appointed, but everyone must consent to such joinder. So there is a bit more flexibility there. In 2014, we did have the consolidation provision. We did see, and as you know, we appoint a consolidation arbitrator There's specific guidance on how that process will be handled, what they shall consider. But we did feel that it had to be broadened somewhat because the previous verbiage only spoke to consolidating the same parties, and here it was extended to related parties. Continuing again on the guidelines of transparency, Article 14.1, that deals with, in fact, the impartiality and independence and further on the disclosures of arbitrators. But we wanted to make sure that everyone knew when we send out the appointment package, as many of you know, the arbitrators on our cases are required to comply with the AAA ABA Code of Ethics. And now that is clearly reflected in the rules, and they sign off on that when they receive their appointments. And then we have a new rule, which, as we all know, the issue of third-party funders has impacted international arbitration, continues to do so. We added new language that the tribunal or the party, the tribunal on its own initiative, mind you, and that's after consulting with the parties, may request the disclosure of the existence of a third-party funder or other non-party, an insurer or someone that has an economic interest, that in fact be disclosed. And the idea, of course, from the institutional perspectives, we don't want to miss a disclosure that should have been made. We want to make sure, to the extent possible, that the award is not subject to mischief later on. And that's why that rule was incorporated. Anne, do you want to share some of the perspectives and discussions regarding the drafting of this particular provision?
Well, I think this is a beautiful example of one of the rule revisions that was driven by the fact that there have been changes in the law. As all of us know, third-party funding started in Europe in the late 80s, then moved into the common law, and now we have, for instance, Singapore and Hong Kong as being the first jurisdictions to pass express legislation to facilitate the funding of international arbitration. It is a technique that is here to stay, and it is seen as a tool for obtaining access to justice. However, you'll note that we did put this under Article 14, which relates to independence and impartiality. And as Loukas stated, the reason we included it there was to make certain that the arbitrators, if necessary, could obtain information to provide full and complete disclosure of potential conflicts of interest. Obviously, there will be instances in which the tribunal is not concerned with third-party funding because the tribunal members have no relationship to any third-party funder, but there may be other instances. In rolling out these rules in the soft launch, there was concern by some that was this being utilized as a method to then springboard for security for cost because there's a third-party funder. It's important to note that the inclusion of this rule is not to allow for security for cost, but to ensure that at the end of the day that there is an enforceable award. And I might add that the third-party funders were very, very supportive of this particular rule when they saw it, because they obviously would like to have that enforceable award.
Thanks, Anne. Any comments?
Loukas, Loukas, can I just, by way of background, in December 2017, CTAC, the China International Economic Trade Arbitration Commission, they launched an investment arbitration rules, and one of those rules, their Article 27, did deal with third-party funding. And it may be at that time, and that's going back a little while, CTAC may have been the only international organization which made a provision. And what Article 27 provided was that as soon as the third-party funding agreement is concluded, the party accepting the funding shall notify in writing without delay to the other party or parties, the arbitral tribunal and CTAC and various others, of the existence and nature of the third-party funding arrangement and the name and address of the third-party funder. And the arbitral tribunal shall have the power to order the disclosure by the party accepting the funding of any relevant information of the third-party funding arrangement. So it may be at that stage, going back a few years, that CTAC was perhaps the first international arbitration institution which dealt with it. As you say, I mean, it's third-party funding is now spread. I think the English opposition to Champerty and the like has softened a little, and third-party funding is certainly being used in the UK, and the English courts have accepted it, but with some reservations, I think.
Thank you, Anthony. John?
We should press ahead. I know we have a lot to get to, so I don't want to get us bogged down on this one.
All right, moving on then to...
I would like to have a comment, because it's perhaps a bit contrary to the modern trend about transparency. I think transparency is in principle good. Where I'm a bit concerned is that the language used in 7b has an economic interest in the outcome of the arbitration. Of course, the economic interest is a matter of measure. I mean, somebody who is a connected business within a group of companies might have an interest in the outcome of the arbitration, not necessarily financial, but in the outcome of the case, because that might be rollover of liability requirements. And this might be a bit difficult to foresee. So there will be a couple of innocent non-disclosures here, which could become problematic. And if you raise the bar of disclosure, there might be some matters where, for example, one might need to have some other adjective before the word economic, a substantial or something like that. And I think, but as we see, this practice will guide us, and I think that's what the arbitration community does, looks at what works and doesn't work, and we have the ability to adjust.
Okay, thank you, Lucas. Moving on, regarding Article 15, as you know, the arbitrators had to be impartial and independent, and challenges were limited to the grounds along those lines where they were perceived that the arbitrators were not in fact acting accordingly. We had to expand the grounds for challenging to include for failing to perform the arbitrator's duties, because we did have numbers of examples where that had arisen. And in fact, the administrator can remove an arbitrator for failing to perform his or her duties, or becomes incapable of performing their duties. A new rule as well is the idea of that Article 17, a tribunal may, with the consent of the parties, appoint an arbitral tribunal secretary in accordance with ICDR guidelines. It's a placeholder, if you will. We are working on the guidelines. We're looking at a number of issues, and of course the devil's in the details, but how in fact will that request be made? You don't want to put the party in an awkward position of having to reject the request made by the tribunal, obviously the ultimate decision maker. What type of disclosures, how they will be in fact compensated. And I've had this example arise twice. We're working on explaining their exact role. In recent cases, I've had arbitrators advise me that their secretary will be conducting research. So we did ask specifically for them to disclose the type of research, how it will be seen and reviewed, and we submitted that to the parties. Any comments here on this particular issue, or? Okay, I'll move on to the next article, which I really think is designed for an issue we have here in the United States and when cases are seated here. And it's Article 21, which added the following language: arbitral tribunal has the authority to decide issues of arbitrability and jurisdiction without any need to refer such matters first to a court. And Anne, why don't you take it over and explain the thought processes behind this article for us?
Well, as you noted, this is purely an American issue for those arbitrations that are seated in the United States. The United States Supreme Court in First Options versus Kaplan took the position that who decides the question of arbitrability, there had to be a clear and express delegation to the arbitrators in order for them in the first instance to determine arbitrability. And although most institutional rules include that the tribunal has the power to rule on its own jurisdiction, and every circuit court in the United States that has addressed this issue has taken that position, that merely reference to the rules is a clear delegation, The recent restatement of arbitration in the United States is taking a differing view, stating that mere reference to the rules in an arbitration provision is not a clear and unmistakable delegation. Therefore, in an attempt to see if we couldn't close that lacuna, this language without any need to refer such matters first to the court was added to the rule.
Thank you. Open it up to discussion to the panel. Perspectives on this rule?
Yes, I mean, really just to echo what Anne said, I mean, one of the reasons this is a distinctively US issue is if you go to any other country in the world, and obviously I can't speak for all of them, but all the major arbitral seats, they will have a statute that provides that arbitrators have jurisdiction to determine their jurisdiction. It's in the UNCITRAL model law. It's in the English Arbitration Act, for example. The US doesn't have such a statutory provision in the Federal Arbitration Act, in large part because the Federal Arbitration Act was passed in 1925 with no serious updates since. It's an old statute that hasn't responded to the needs of the time. And so, the Supreme Court is, so this issue in the US, unlike in other countries where it's addressed by statute, it's addressed by case law, and it's actually a confusing set of cases. But there is one fundamental rule: arbitrators can determine their own jurisdiction if there's clear and unmistakable evidence that the parties agreed that the arbitrators had that authority. And it's unfortunate, I think, that the restatement took the position that it did on this. It's one area where I do disagree with the restatement, but I think you ought to be commended, Anne, and the committee on actually tackling this. And I think your proposed solution has to be right. It's hard to imagine a court not viewing that as clear and unmistakable evidence the way you've drafted it.
We shall hope so.
Yeah.
I've been curious myself, and the panel would probably know, but have other restatements in other areas of law generated this much debate and discussion? But that's for another day and another subject.
Well, I think the interesting question here is that the arbitration restatement is not a traditional restatement in some respects, in the sense that having attended some of the earlier meetings, there were several gaps where there was no jurisprudence, and effectively there is a rule suggestion with a number of very good intentions, for example, internationalizing the US as a jurisdiction and bringing very much flavor from civil law influences, but some of them are not reflected in US jurisprudence, and I think that is really the conundrum there.
That's true. All right, moving on, the next provision was Article 22.2, and as I had mentioned, this is the provision that allows for video, audio, or other electronic means during the proceedings. As I had mentioned, the previous versions, there was no prohibition to using videos, and in fact, there was a reference to the ability to use technology, but obviously we did want to make it clear and include this verbiage clearly in the rules. We also, as you may know, on ICDR.org, there's a box there for our experience with virtual hearings. I'd prepared a set of guidelines to consider for using, for example, the Zoom platform, the settings, the issues that the parties should consider so they can do their due diligence. And there's also model orders that the arbitrators can use to discuss this with the parties, includes some verbiage as to how they are going to proceed, including verbiage as to proceeding over a party's objection. And we're also tracking, for example, if you go to that site, daily it's updated, the stats. We've had over 10,000 instances of virtual hearings. Of course, that's the ICDR and the AAA combined together. But I know the panel had some issues and they wanted to chat about this. I'll open it up to discussion.
Louis, can I mention, of course, Anna's already said that COVID hadn't happened when the rules were being looked at, but it's now been brought in. And of course, other organizations like the LCIA and the ICC have done the same. I would think it's probably the case that international arbitration may have been less affected by COVID than other areas, because in international arbitration, we already had provisions in most of the major international arbitration rules dealing with things like documents only. I suppose you could regard those now as effectively virtual or helping virtual. But what is so important about the ICDR provisions, as you say, are the provisions of Article 22 and Article 26, and the two guides which the ICDR have issued, and in particular the model order. As you say, Article 22 provides that an arbitral tribunal may conduct an arbitration in whatever manner it considers appropriate, provided, of course, the parties are treated equally. And Article 26 states that a hearing may be held by video, audio, or other electronic means when the parties agree or where the tribunal determines. So that's quite interesting, because it means that an arbitral tribunal can order a virtual hearing even if one or more of the parties objects. Those two articles, 22 and 26, are the important ones. There are the guides. And I think particularly significant is the model order. For example, in relation to witnesses, the model order sets out the requirements for the giving of evidence by witnesses at a virtual hearing. And I think it's one of the concerns about virtual hearings is in relation to the giving of evidence by witnesses, because there is always the danger that not an expert witness, I wouldn't have thought, but a witness as to fact may be coached. And so the model order provides that a witness giving evidence is to sit at an empty desk, and the witness is to be clearly visible in the video. And to the extent possible, the webcam is to be positioned at face level, relatively close to the witness. So there's some interesting provisions there in relation to dealing with that. Other institutions have dealt with the same problem. The LCIA rules came into effect on the 1st of October. Their Article 19.2 contains provisions for video conference and so on. ICC is the same. Article 26 contains provisions for video conferencing, telephone. And maybe the latest one is Article 27 of the Swiss Arbitration Rules. Short and sharp, any hearing may be held in person or remotely by video conference or other appropriate means as decided by the arbitral tribunal after consultation with the parties. So it's the ICDR rules, the guides, and the model order, I think, are exceptionally important.
Thank you, Anthony. And I will say this, it remains to be seen what happens as we exit COVID. I do believe that hearings in person, people will return to them, but certainly a hybrid model. Previously, as I said, many of the procedural phases were conducted telephonically. I can see us using video more for those stages. A hybrid hearing in our Midtown offices in New York. Also in Florida, we've updated the audio-visual equipment. It's really incredible what you can do with state-of-the-art cameras. You see the whole room. You can isolate on the counsel doing cross-examination of a witness, see the entirety of that. And I think there's some attraction there to having that accessibility, that perhaps parties may want to extend the viewership privileges to their clients, etc. So it's just another tool and using technology, which only makes sense. But I still think you do need, and people will have the feel they want to be in the room to fully gauge the perspectives of the arbitrators, which is hard to do, I think, on the Zoom platform. Any other comments on that? Okay, moving on.
I have two. Sorry,
go ahead, Loukas.
I think I have two short comments. One is, I think we have to accept after 16 months that online hearings are a reality and to stay with us. The only concern I have about online hearings is whether they provide an impediment to settlement, in the sense that when you bring the parties and the tribunal in the same room at the time of the coffee break or whatever drink one would like to have, there's some discussions which sometimes break the ice between the parties particularly, and they might have some more scope for settlement, which of course online hearings do not facilitate. And the second is that tribunal members who are not known to each other, it takes also some time to develop a dynamic, which inevitably means that the chair takes a much more substantial role, which of course in many cases the chair has in drafting decisions and in moving the process forward. So it becomes a bit less collaborative.
John?
One comment and one question. The comment is this: in the last set of virtual hearings I had, I mean, I was just interested that, because you can see the number of participants if you're on Zoom, as you can see now, 40 participants. And the reason was both sides had an in-house lawyer and a client representative there, but both sides also had a series of junior associates who were actually getting experience. It's hard to imagine a hearing room that could easily accommodate 40 people, but you have them. But this certainly, if this were a live hearing, it would have been probably 12 people. So it was interesting to observe that, because I do think it actually gives junior lawyers, it's an opportunity for junior lawyers to get experience. The question I have is the way I read the new rule, and maybe I'm reading it wrongly. I can understand the tribunal saying ordering virtual hearings where the parties disagree. One wants physical, one wants virtual, because there could be nefarious reasons such as delay for insisting on virtual. But the way I read the rules is actually the tribunal could order virtual hearings if both sides want physical hearings. Am I reading it wrong? And I'm just curious about that, if I'm reading it right.
Anne, what's your take on that?
I would suggest that you're probably reading it correctly, but I would also suggest that an issue of a tribunal ordering a virtual hearing over the objections of two parties that want it in person would probably be very rare. And I think that those instances would be, for instance, when the tribunal members themselves, for some health reason or something else, felt that they couldn't have a physical hearing. But it also, as we know, has to be balanced with the party's right to be heard.
Yeah.
So that in turn might take you back to what Loukas talked about earlier, which is if the parties were really dead set on having a physical hearing, does that rise to the arbitrators being unable to perform their duties, which is a discussion for another day, obviously. So hopefully that sort of thing would be very rare, John, but I do think you're reading it correctly.
Yeah, the health reason I understand. It's the something else that worries me a little bit. I've heard a lot of arbitrators, and I think we've all heard it, them say, I'm loving this. I'm not one of those who love this. I hate this. I want to be in person, but I'm loving this. I can get up, I can do the hearings, I can get on with the rest of my day after they're over. And that's what I worry about, actually, is that giving arbitrators that power, there is a possibility of abuse. Both parties want physical hearings, but you know what? I love doing virtual hearings. I can stay in my country house and do them or whatever. But I guess it's to be seen. It's to be seen.
Yeah, keep in mind that that's risky in that obviously if one side challenges the tribunal and the other side agrees, the arbitrator shall withdraw. So it's very easy for the parties to fire the tribunal. I don't see it happening too often, but that remains to be seen. Moving on quickly. So as I mentioned, we had the rule that provides the parties and the tribunals the requirement to discuss the issues related to cybersecurity. And by the way, in the initiation package, we have a cybersecurity checklist that we send out with all the issues that should be considered and discussed, along with privacy and data protection. And then we have a new rule regarding the Article 23 that the parties may request permission to submit an early disposition application of issues that have a reasonable possibility of success or dispose of or narrow issues in ad economy. Again, this is something that we had seen all along because the previous version did not prohibit that, but now it's included in the rules. Any comments on that? Okay, I'll move on. There's also under Article 26.4, we did change the wording that unless otherwise agreed by the parties or directed by the tribunal, evidence of a witness It was switched from may be presented in the form of written statements to should be presented in the form of written statements. And we think that's really consistent with international practice and very helpful. And then perhaps one of the lessons that were learned during the course of COVID, we introduced Article 32.4, electronically signed orders or awards can be used unless the law, the administrator, or party agreement provides otherwise. And then we looked at some of the financial issues that we encounter. In Article 39.4, it's a situation where a party may have to advance the costs for another side that is not paying their share. As we all know, when you enter an arbitration agreement, you are envisioned that you will pay for 50% of the administrative and the arbitrator's compensation. Sometimes a party refuses to pay. So the rules provide that we can ask the other side that is making the payments to advance the costs for the parties that are not paying their share. And the rule was revised to say that a party can actually, at that point, once they've done so, request the tribunal to make a separate award for any fees that they pay in advance of the other side. Keep in mind, by the way, in the example I posited, if let's say the claimant isn't paying their share of the fees and the respondent does cover them, the claimant's claims are actually deemed withdrawn. Now, they can defend against a counterclaim, but their claims themselves are deemed withdrawn. And then wrapping up on two last revisions, as you know, the ICDR in the 2014 version had the possibility of publishing awards that became public during the course of enforcement. Here we also extended that we can publish awards unless a party objects within 6 months of our transmitting the award. And we are obviously, we think that these awards would be very helpful to shed light on how arbitrators deal with contractual provisions in various business sectors. We see some extremely well-written awards, but it's not intended to be a gotcha moment. So administratively, we'll remind the parties early on of the existence of the rule, and then we'll be very clear to obtain clear permissions when we transmit the award, so that if they do object, of course, we won't publish the awards. And then finally, on the expedited procedures, which were introduced in 2014, extremely well received, we raised the threshold of their applicability from $250,000 to $500,000. Of course, they're flexible enough that parties can, by agreement, adopt them in their entirety or any of the provisions to a larger case if they desire to do so. And if it's 100,000 or less, the presumption is that it will be on documents only. As for a hearing, those rules, we don't encourage a hearing, but again, obviously made easier in the new virtual hearing climate that we have seen now in existence today. So those were the main points. I'd like to just go around for any final observations or comments regarding the rules themselves or any of the particular provisions that we haven't addressed. Anne, I'll start with you.
Well, I have nothing to say other than I really do appreciate the comments that we've received from the other panelists about the rules, and I greatly appreciate the compliments, as you might imagine.
Thank you, Anne. Gentlemen?
Just a quick one from me on the new rule entitling a party that has advanced costs when the other party didn't pay them to seek an award from the tribunal. The LCA has a comparable rule, and I was recently involved in a case where such an application was made, and actually the very fact of the application led the other party to pay up. So, you know, this could actually have, you know, you can get to its intended effect without having to go all the way to an award. So I think it's to be, you know, good that that was added in.
Thank you, John. Loukas?
Well, Lewis, can I just add, the rules generally are so impressive. Perhaps in particular, the rules dealing with third-party funding and mediation. The link between mediation and arbitration is quite significant if you look at the use of step clauses. The link, I think, is important, and therefore what the rules have now done in relation to mediation, I think, is significant. The virtual provisions I mean, I think to some extent, regardless of how the pandemic develops, and I suspect it's with us forever, but regardless of how it develops, I think we're going to have a mixture of virtual and in person. And I think the hybrid arbitration hearing is going to be something that we may find in the future. If I can just take a very simple example, I mean, some years ago, I was sitting in London in international arbitration. One of the parties insisted that a witness should come from America to the London hearing to give evidence. And then for whatever reason, that party decided, once the witness was in London, that they wouldn't cross-examine the witness. Now, the costs of that on an in-person hearing would be significant. If you imagine that happening now with a virtual hearing or a hybrid hearing, the costs would be minimal, next to nothing. I think the virtual hearing is with us, probably in a hybrid form.
Thank you, Anthony. Loukas?
I have three fairly short comments. The first is, of course, that the ICDR continues with having rules which are both mainstream but also innovative. And I think amongst competition, I mean, with the competition amongst arbitral institutions, trying to maintain innovation, but without looking completely out of place is a challenge. And I think you've been doing that very, very well. So what I particularly like in this revision is that there is much more response to the quest for efficiency and procedural economy. And that is in two different ways, by partly empowering the tribunal in some respects, like a disposition of matters, and even given more discretion to the tribunal on joinder and consolidation, but also sort of the use of technology. And the third comment is a comment that is linked to the last one. Of course, the biggest problem in commercial arbitration at the moment is the involvement of third parties. And although this has been an open discussion, we still operate largely on a basis of consent. So I see the very small but significant steps that are being done in that direction, and how we reconcile that with developments in case law from courts in all jurisdictions, including from the US last year and in other places, is a challenge, because I think parties need to have the comfort that the consent is being upheld to the extent possible, while the efficiency is there as well. And in that sense, I mean, I can commend ICDR and Anne and the committee for trying to be and not just balanced, but trying to move things forward, but with appropriate steps.
Well, thank you, Loukas. Well, I'll just tell everyone, I'm sorry, there were a couple of questions. I took the information down. I'll respond to you directly. We ran out of time. There is an article that Anne has written on the ICDR.org site that highlights the rules revisions. I invite you to visit that, and you can obtain further information on that. I would like to give you my applause, since we don't have an audience in person. Thank you all very much. It's a pleasure. I appreciate the time you took to join us here today, and we will let you know when the conference is posted for anyone who'd like to see it again, or invite others to hear our discussions. It was sincerely my pleasure to have you all here. Thank you all very much, and have a good day. Thank you.
Thank you.